welcome to Litigation Help. My name is Heather Huilitwin, and today we're going to talk about wrongful dismissal in employment law. I'm particularly excited to get into this topic today because there have been some new developments in this area of law. And so joining me here today is Toronto lawyer Samuel Michaels of SM Legal. Samuel is our regular speaker on employment law, and you can check some of the videos we did together earlier by clicking on the I button above or using the links in the description box below. Welcome back, Sam.
Thanks, Heather. Great to be back. Looking forward to talking about a fairly loaded part of employment law.
Oh boy. Okay. So,
Yeah.
but actually, before we get into that, maybe could you give us a little background refresher? So, what exactly does wrongful dismissal mean?
Yeah, absolutely. So when someone's terminated or let go from their job, so we're talking about basically any situation other than a resignation.
Right.
That's you're told you're being let go. You're told, pack up your things. You're told you got 3 months left. Your job conditions are so severely changed. Your employer says you were paid $100,000. Now we can only pay you $10,000 a year. That's a type of situation called a constructive dismissal. That can also be a type of termination. So any termination, anything under that bucket, the umbrella is wrongful dismissal where the person hasn't been adequately paid or given adequate notice. And
Mm.
of course, that becomes, this complicated legal question of what is enough notice. But the idea generally is it's a wrongful dismissal if there was no good reason for the firing and the person wasn't given sufficient either payment, we're paying you out a month, 6 months, a week, whatever it is, or notice in advance of that firing. So, we're letting you go in 3 months, so you have a 3-month period to look for new work. So wrongful dismissal is any case where that's not provided or sufficient notice or pay in lieu of notice isn't provided. The other side of the coin, of course, is where the termination is justified. And that's a very limited scope in Ontario. And I'm looking forward to getting into that more as we get into the talk today.
Yes, because that's a great segue to kind of like the case that I wanted to bring in today, which is called, I think, Waxdale versus Swagon. I don't know if I'm saying that right. And so anyway, I was wondering if you could give us a little like a bit of a high level summary of like what are the takeaways of that case?
Yeah, absolutely. So Roxo, this case happened in 2020, and here we are filming 2023, and it's still being dissected and still affecting employment agreements and probably will for years to come. It's a very
Mm,
important decision, I think, for Ontario employment law.
mm,
And basically, what happened in the case is that you had an employee who was fired,
hmm
and they said the termination clause, the clause in the contract, said that there'd be no pay for a just cause firing, and there would be termination pay if the firing was without cause. What the court looked at is the court looked at the Employment Standards Act of Ontario, which is sort of the governing law for the province and all the employee rules, minimum wage, vacation pay, termination pay, all that stuff. And the court basically said this distinction isn't allowed under the Employment Standards Act. The Employment Standards Act just says if you're fired, you get paid. The only exception is under a regulation, which we'll get to a bit later because this actually didn't come up in the case itself. And the employer in the case acknowledged, they basically said, yes, the just cause portion, the portion that says no pay,
hmm
is not valid. But the without cause portion that allows for some pay, but not as much as the employee wanted, they
hmm
said that is valid. That's fine. There's nothing wrong there. And the court said no. And in saying no, the courts basically invalidated tons and tons of employment agreements. So what the court said is if you're looking at the clause of the termination clause and the first part or one section is not good, is not valid under the ESA, the Employment Standards Act, the whole clause is no good. The whole termination clause. And once that whole clause was no longer valid, the employee said, I want more termination pay. And there's no limitation under the contract anymore.
Yes.
And the court said, you're right. You are owed more termination pay. And that set the boulder rolling down the hill.
Oh
And so
my.
here we are looking at all types of contracts and all types of termination clauses and looking if there's even one sentence that contradicts the Employment Standards Act. Because if there is, that whole clause is out the window. And when there's no clause at all, it basically just comes down to the court. The employer can say, hey, I paid them out 2 weeks. I think that's reasonable for XYZ reasons. The employee says, I'm owed 2 years. I think that's reasonable for ABC reasons. And then a judge says, somewhere in the middle, or they say the employer's right, or they say the employee's right, which obviously is a more confusing state of affairs. So what lawyers are now trying to do is fix the employment clauses, fix the contracts and those termination provisions to hopefully bring back those limitations, but without the risk of running into a clause being invalidated by the court. Long story short, the court's basically said if there's any issue with your termination clause, the whole thing's out the window. So that's caused a lot of problems and a lot of rewrites and amendments from employment agreements.
I see. So I know that there's something called the severability clause, which I think I remember even in my contracts. I thought that would save the employer. Does it not save the employer? No?
Okay, so I want to peer behind the curtain because I got your notes before for our presentation,
Yeah.
and I was looking at this question, right,
Yeah.
about the severability clause, and I found conflicting information. So I think it's a
Oh,
really good question to look
okay.
at because I did actually find presentation from a lawyer in Ontario
Yeah.
saying severability clauses are more important now because of Waxdale and what's happened. And a severability clause, basically a clause that says this portion can come out of the contract, but the rest of the contract is still okay.
Yeah.
And I found other resources and other lawyers, and even the wording in the Waxdale decision from the court seems to me to point in the other direction. That
Really?
when it comes to this specific issue,
Yes.
so the court said for the termination clause specifically, you can't go sentence by sentence. That's very clear,
Okay. Right.
right? So the court said you can't extract one sentence and not another.
Right.
The question is, let's say your termination clause is broken up into sections, right? You have a just
Right.
cause section, you have an unjust cause section.
Yeah.
What I would say, I would lean on the side of caution that the severability clause is not really going to save you.
Wow.
Maybe the severability clause will help in an unrelated thing. For example, if you're in a termination claim and the court's looking at the contract and they say, hey, I noticed there's something weird in this confidentiality clause, but
Right.
it's okay because there's a severability, right? It can be severed out. So they might say like a problem in an unrelated part of the contract. I think you could be okay for that.
I see.
Let's say your confidentiality clause says I'm binding the employee for 10,000 years, which, as we both know, you're not really supposed to do, right? It should be sort of reasonable timelines.
Right.
So I could see in that case, the court would say, yeah, that's not valid, but this is a termination claim. It doesn't really affect the claim.
I
There's a
see.
severability clause. We're okay to sever it out. When it comes to the termination provision specifically, I would lean on the side of caution. I would say if there's any flaw anywhere along that termination clause or clauses related to termination, there's going to be some risk, right? I wouldn't rely on, oh, I have a clause at the end of the contract that says, I can extract parts that don't work. That's a risky play moving forward.